Okay, I just want to do a quick video on the Terraform case. Some news came down a couple days ago. Terraform, that's the Do Kwan case for those of you who haven't been paying attention. They tried to get a summary judgment against the SEC demand for a jury trial, the SEC suit. And what that means is the lawyers for Terraform and Do Kwan decided to request summary judgment saying this doesn't apply and we would like to get it dismissed. Easy judgment, get it out of our face. And there's no reason for the SEC to be able to get a trial for this because we've got this ruling, among other reasons, but one of the things they cited was the XRP decision from a couple of weeks ago. Jed Rakoff is said to have ruled against the Howey test. Well, that's not exactly what he did. In some ways he did, but not completely. Does this mean the Howey test does not apply? No, it's far too premature to say that. There's other videos out there saying, haha, look at this, the Howey test still applies. This is going to go down to each cryptocurrency. It's not going to be one decision, one cryptocurrency, therefore it applies to everything. It's going to be very fact-based analysis. And does this mean the XRP ruling is thrown out? No, it does not. Now, let's just go over it. The Howey test is an investment of money by a common enterprise with the expectation of profit from the work of others. And this is where it fell apart for XRP, the from the work of others for the programmatic, that is the retail investors. They were found to not be as influenced by the managerial efforts, work of others, because there was that much of a distance from them versus the institutional investors. And there were other factors too. In the XRP situation, a very small percentage of the coins were sold at retail. Most of them were sold at institutional levels. The institutional coins were found to be securities. The retail/programmatic was not. And to say that this judge here, Rakoff, went out and disregarded the XRP decision, that does not mean that instantly all cryptos from here on out are going to be considered securities, even if they're retail. There are key differences. The XRP ruling was not applied because the facts are not the same. I'm just going to go over this one particular thing that stood out to me. Here we go. Judge rejects motion to dismiss Terraform case, disagrees with Ripple decision. Well, he disagreed with applying that as it was in the Ripple case to the Terraform case. And of course it says, for the purposes of this motion, well-plead allegations must be taken as true, yada, yada. Okay, so the SEC gets their trial. But if you actually go into the decision here, he mentions the judge, not by name. This is the Terraform. It's a decision denying summary judgment for Terraform. Okay, it says, in doing so, the court rejects the approach recently adopted by another judge of this district with a similar case, SEC versus Ripple. There, the court found, and it goes over what it thought. Whatever the expectation probably they had could not, to that court, be ascribed to the defendant's efforts. It said that, that was their decision. He says, but Howey makes no such distinction between purchasers. Sounds like he's ruling all the way around how he's going to make a distinction. Well, he sort of does. He leans that way, but makes good sense that it did not. The purchaser bought the coins directly from defendants, or instead a secondary resale transaction has no impact on whether a reasonable individual would objectively view the defendant's actions and statements as evincing a promise of profits based on their efforts. Okay, he's still saying that secondary versus primary institutional sales, they all depend on the efforts of management. Indeed, if the amended complaints allegations are to be taken as true, as again, they must be, defense embarked on a public campaign to encourage, here it is, both retail and institutional investors to buy their crypto assets by touting the profitability of the crypto assets and the managerial and technical skills that would allow defendants to maximize returns on investors' coins. Okay, Terraform and Do Kwan were marketing to institutional and programmatic, that is retail investors. That didn't happen with Ripple, not to the same level. In Ripple, programmatic sales, this is the Ripple decision, also lacked other factors present in the economic reality of the institutional sales, which cut in favor of finding a reasonable expectation of profits to be derived from entrepreneurial or management efforts from others. So, for instance, programmatic sales in Ripple, XRP, were not made pursuant to contracts that contain lockup provisions, resale restrictions, indemnification clauses, or statements of purpose. Similarly, Ripple's promotional materials, such as the Ripple Primer and Gateway's brochure, were widely circulated amongst potential investors like the institutional buyers, but there is no evidence that these documents distributed more broadly to the general public, such as XRP purchasers on digital asset exchanges. Nor is there evidence that programmatic buyers understood the statements made by Larson, Schwartz, Garlinghouse, and others were representations of Ripple and its efforts. There is the difference. In Ripple, the retailers did not get contacted directly and were not really privy to the things the institutional people were, but that's not the case Here, he says it right here, defendants embarked on a public campaign to encourage both retail and institutional investors to buy the crypto by touting the profitability. So they're touting it to the public to the retail. That's the difference here. I'm not the only one who thinks this. This is Holland and Knight. They haven't gone over this case yet, but they talked about the XRP decision. Torres highlighted several XRP and Ripple specific factors that weighed in favor on finding the programmatic sales did not constitute securities for transactions. For example, and it goes, programmatic sales represented less than 1% of the XRP global trading. Promotional materials that distributed to institutional investors not widely circulated. And 3, wasn't evidence that programmatic buyers understood. Just like I said, okay, it's right there in the opinion. So if you hear somebody saying that this doesn't apply, the Howey test is out the window, that's not true. That does not mean the first judge didn't know what she was talking about. There's other videos out there saying that. I'm not going to say who, but if you're following this case, you'll be able to find out, who's trying to take their victory lap right now. That's not what's going on. We still have to see what's going to happen at trial. All this decision did here, this ruling for Terraform was deny summary judgment. And it means that they're going to have to face the music at trial with the SEC. That's what Judge Rakoff determined. Don't get ahead of yourselves. Also remember that this does apply to other types of cryptocurrencies. Every one of them is going to have to get analyzed by the SEC to see these factors. And one that comes to mind potentially is Hex, because they were doing a lot of marketing to retail. I think Hex, retailers, those tokens sold at retail stand a greater chance of being determined securities based on all of the back and forth between Richard Hart himself and his followers. So we'll have to wait and see on that. I don't want to get too off the subject, but I just wanted to clarify that. Hope you're having a great day. Leave some comments below. Thank you.